Ladies and gentlemen, please rise to welcome our chief guest, Honorable Sobitha Rajakaruna, Justice of the Court of Appeal, who is accompanied by the President, Secretary, and other members of the Management Committee of the Bar Association of Sri Lanka. To begin the National Labour Law Symposium on an auspicious note, we would like to invite the following dignitaries to light the traditional oil lamp. Our chief guest, Honorable Justice Sobitha Rajakaruna, Judge of the Court of Appeal. Mr. Salya Piris PC, President, BASL. Mr. Rajiv Amarasuriya, Secretary, BASL. Mr. Rajendra Pereira, Treasurer, BASL. Mr. Prasindu Silva, Assistant Secretary, BASL. Professor Arulanandam Sarveswaran. Miss Lakshika Ratnayaka. Miss N. Devananda. BASL CEO, Mrs. Surani Samarasekara. Mr. Kalinga De Silva. Mr. Prakalandam Thurai Singham. We would also like to request two participants from the audience to join our dignitaries to light the traditional oil lamp. I call upon Mr. Azwa and Miss Vijayaratna. Thank you all. The following dignitaries are now invited to the head table to take their respective places. Honorable Justice Sobitha Rajakaruna, Judge of the Court of Appeal. Mr. Salia Piris PC, President of the BASL. Mr. Rajiv Amarasuriya, Secretary of the BASL. Mr. Rajind Pereira, Treasurer, BASL. Mr. Pasindu Silva, Assistant Secretary, BASL. Professor Arulanandam Sarveswaran and Ms. Lakshika Ratnayaka. May I request the entire gathering to rise for the national anthem.
Sri Lanka Mata, Apa Sri Lanka, Namo, 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 Namo Mata. Sundara Siri Barini, Surali Ati Shobhaman Lanka. Ranya Dhanaya Nekamal Palaturu Pirijaya Bhuviya Ramya. Apahata Sapa Siri Sita Sadhana, Jivana Ye Mata. Viliganu Mena Apa Bhakti Puja, Namo Namo Mata. Apa Sri Lanka, Namo 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 Mata. Ubave Apavidya, Ubamaya Apasatya, Ubave Apashakti, Apahadya Bhakti, Apa-apa-aloke, Apa-ge anugrane, Apa-apa-jivanave, Apa-muktiya bhogave. Nava-jivana devine, nitina apa-kubudu karan mata. Jaya Veera Vadavami Naragena Yanu Mena Jaya Bhumikara. Ekamavakage Daru Kalabhavina, Yamu Yamu Vidopama. Prema Vada Samaveda Durarada, Namo Namo Mata. Apa Sri Lanka, Namo 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 Mata. Apa Sri Lanka, Namo 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 Mata.
Thank you, everyone. Please take your seats. I would like to now invite Mr. Rajiv Amarasuriya, Secretary of the Bar Association of Sri Lanka, to make some opening remarks.
A very warm welcome to all of you to the National Labour Symposium 2021 of the Bar Association of Sri Lanka. Also a very special and warm welcome to our chief guest, His Lordship Justice Sobitha Rajakaruna, for not only gracing this occasion, but also agreeing to deliver the keynote address today. This is a symposium which had been planned to be conducted even before I took over as secretary, but could not. First, due to the Easter attacks, and thereafter, of course, the pandemic. And I'm personally very happy that we are able to hold this important event today in spite of the many difficulties and hurdles we all face. Labor law and industrial relations are particularly relevant and critical at this juncture in the new normal, where everything is happening differently and often with a twist. It is therefore particularly timely for us to have this discourse on a topic which has impact and ramifications across our economy at a time when we all together have a common hope and aspiration to take our country out of its present predicament. As an employer, you may often wonder why the legal regime is so employee-friendly. But as an employee, you may appreciate the same when you come to realize that, in fact, there is an uneven status between yourself and your employer. This is a perennial issue which requires proper balance and perspective and has now been given a complete new spin due to the new work environments. That is why we also decided to give more focus to the new issues at hand and look forward in the landscape of industrial law through this conference. I take this opportunity to call upon every one of you to please make this an engaging discussion by posing your questions at the end of each presentation, so that we could not only learn from the presenters, but also learn from the experiences of each one of us. At the BASL, we were faced with these same difficulties and restrictions of the pandemic, but we took the risk and did things differently, and it worked out better than even planned. We went digital very early on and converted all our activities into the digital space, from the launching of webinars and then to the online certificate courses, the virtual meetings, and then to the launch of the state-of-the-art and interactive website equipped with an online e-store, and then hybrid conferences like this, and the list goes on. The transition we have had to the BSL gives me a lot of personal satisfaction. We have seen the changes and the benefit of the same, and we are now functioning in a completely different space. Today's symposium is also part of that thinking, and we will, at the BSL, continue to push the boundaries wherever possible. Before I conclude, I must take this opportunity to thank the BSL Program Office, which is behind this symposium, and particularly Mr. Kalinga De Silva, who took up much of the burden in organizing this conference together with Mr. Prakalatan Thuresingham and Mr. Saranga Hettiarachchi, and of course, Assistant Secretary Mr. Pasindu Silva, Ms. Lakshika Ratnayaka, and Ms. Ann Devananda for all the support. We have a full day of extremely interesting and a professional lineup of sessions, and I will conclude by extending my very best wishes to this symposium and all the participants for an insightful and thought-provoking sessions. Thank you.
Thank you very much, sir, for the opening remarks. Next, I would like to invite Mr. Salia Piris PC, President of the Bar Association of Sri Lanka, to address the gathering.
Justice Sobitha Rajakaruna, Judge of the Court of Appeal, Mr. Rajiv Amrasuriya, Secretary, Bar Association of Sri Lanka, Mr. Rajin Pereira, Treasurer, Mr. Pasindu Silva, Professor Arulanandan Sarveswaran, Ms. Lakshika Ratnayaka, ladies and gentlemen. Let me first of all welcome you to the symposium and thank you for participating in this. Today there are both members of the legal profession and non-lawyers who are present at this symposium. And I think this symposium is a long-felt need, and as Rajiv said, for some time the BSL had been thinking of organizing this, but due to various reasons, we have been unable to proceed. So I think it is important that we are having this symposium. Labor law, or as at Law College we call it industrial law, I think forms a very important part of our profession, not only of our profession, but of the legal fabric of this country. When we talk of rights, people very often think of only fundamental rights. But I think a very important component is the rights of the employees, and of course balancing them also with the needs of the employer. And it becomes all the more important because in times such as these, when Sri Lanka looks forward for investors to come in, there is also a need to realize trends in other countries. And so this symposium is, I think, very important. And also, I think, the legal profession for young lawyers in Sri Lanka, this is a new avenue which should be explored. Very often when we thought of industrial law or labor law, we think only of the labor tribunals or making representations at the labor department. But there is another vast area, and I'm sure the new Retirement Act might provide some more a new area to explore where professionals, legal professionals are concerned. So I think this is important. Continuing professional development for members of the profession who are participating in this symposium. Continuing professional development is of absolutely importance. The Bar Association is discussing the way forward in respect of continuing professional development, because in most other countries, CPD is mandatory. So far in Sri Lanka, we have not made CPD mandatory, but I think the future of the profession, it is in the interest of the future of the profession to make a continuing professional development, participation in symposiums such as this and in seminars mandatory. And in the years to come, we will explore that possibility in discussion with, of course, His Lordship, the Chief Justice and the Supreme Court. The bar needs to understand that we have to look at new avenues, new areas. We talk of an expansion of the legal profession, but as the profession expands, we must also look for new areas for our members to be involved in. 2 weeks ago, we were at the Junior National Law Conference, and there was a session which was sponsored by the Colombo Stock Exchange. And at that conference, Dr. Aritha Vikramanayaka, who was one of the speakers, pointed out about the new SEC law and the scope found in the new SEC law and the scope which is there for members of the legal profession. So similarly, labor law also is another area, human resources. So we have to look at these and try to encourage members of our profession, especially the younger members of our profession, to be concerned in these new areas, because I think the future of our profession lies in finding new areas, new sources of practice, and not necessarily be confined to the courtroom. And this is message which we must send to younger lawyers. So let me wish you an insightful conference. I must say that the presence of Justice Sobitha Rajakaruna is, we warmly welcome him. His presence is very encouraging for many reasons. Justice Sobitha Rajakaruna, on a personal note, Justice Sobitha Rajakaruna was my batchmate at Law College, and also we were in the Department of the Attorney General together, and he has always been a friend of the legal profession. I must also thank Rajiv and the Lakshika and the seminars committee for all the effort they have put in. And of course, Mr. Kalinga de Silva, Mr. Thuresingham, and the others in the Bar Association office. I wish to thank them for all the effort that has been put in. So thank you very much, and I wish you a good conference.
Thank you, sir, for those heartwarming words. The next item on the agenda is the most awaited keynote address on the topic, Trends That Need to Be Emerged in Sri Lankan Labour Laws and Practice, which will be delivered by our chief guest, His Lordship Justice Sobitha Rajakaruna. Justice Rajakaruna requires no special introduction, but we certainly would be failing in our duty if we do not say a few introductory words about him. His Lordship Honorable Sobitha Rajakaruna joined the Attorney General's Department as a state counsel, served almost 27 years before he was elevated to the Court of Appeal. He was holding the post of Senior Deputy Solicitor General at the time of his elevation, and he was a supervising officer of the Civil Division of the Attorney General's Department. He was the supervising officer on labor law and labor tribunal work for many years. He has obtained a Master's of Law degree from the University of Colombo. He has followed commercial law and professional development programs at the National University of Singapore and at the Deakin University of Australia. Mr. Rajakaruna has been awarded the Certificate in Adjudication by the Kuala Lumpur Regional Centre for Arbitration in Malaysia. He is also the book titled Changing Party Allegiance and Termination of Parliamentary Mandate. It is a book written considering the constitutional aspects of the relevant subject. He was appointed by the SARC Arbitration Council as an arbitrator, expert to the panel of arbitrators of SARC Arbitration Council in the year 2014. He was also appointed as an adjudicator by the Kuala Lumpur Regional Centre for Arbitration. His Lordship has represented the Attorney General at the Working Committee on amending the atomic energy law in Sri Lanka. He has also assisted and participated in many negotiations with the experts of the Atomic Energy Agency in Vienna and has provided much guidance and assistance in the field of atomic energy law to the Atomic Energy Authority of Sri Lanka since the year 2010. He was also the visiting lecturer for the subject of constitutional law at the Sri Lanka Law College for several years. He has served as a guest lecturer at the Bandaranayake International Diplomatic Training Institute and Staff Defence College, Sapugaskanda. Sir, we eagerly await your keynote address. Please take your place at the podium.
Good morning, everybody. Mr. Salia Pires, the President by Association, Mr. Rajiv Amarasuriya, the Secretary by Association, Professor Saravanesan, and the other distinguished members of the head table, colleagues, friends, ladies and gentlemen. It's indeed an honor for me to get this opportunity to share my thoughts with this distinguished gathering this morning. I have had the privilege of actively participating in national labor law symposiums organized by the Bar Association on several occasions before. It is no doubt that many lawyers who are practicing labor law are being immensely benefited with this type of sessions. I'm very much thankful to Mr. Rajiv Amarasuriya, our able and energetic secretary, for inviting me. And also I wish to thank our president, Mr. Salia Pires, for his great leadership. In fact, I wanted to place on record before Mr. Pires that I'm happy to announce that I'm a batchmate of Mr. Salia Pires, but he announced before me, so I will go one step further and I would say we were in the rival groups of the law college. That is all the more why I always say from the day one I met him up to date, he's a perfect gentleman and a good friend. Thank you, Mr. Pires. The employment relationship has been described in the Blackstone commentaries as the third most important human relationship next to parent, child, and husband and wife. Naturally, employers as well as employees want it to be a continuing relationship for the mutual benefit of each other. With the evolution of new economic development projects in the world and with the emergence of a new layer of literate youth in the society, the relationship between the employer and the employee has changed. COVID-19 pandemic created a new era for the employment sector. Globally, the year 2020 sent shock waves through various employment modalities requiring organizations and business to adapt into a rapidly changing environment. For many organizations across the world and even in Sri Lanka, this volatile environment compelled employers to make significant changes to their business, such as shifting to a remote full-time staff management, determining how to support employees through pandemic, managing a hybrid workforce, and addressing legal concerns around the COVID-19 pandemic. More importantly, economic disruptions and the contractions in the global labor market due to the COVID pandemic affected the quality and the quantity of jobs. With the rising economic hardships, we witnessed multiple examples of increased levels of informal types of work, lower remunerations, employment transfers, and layoffs across the globe. Sri Lanka was no exception to this. The economic conditions associated with the pandemic created a number of complexities in the job market, especially among the informal workers. Considering the totality of the circumstances, there is a pressing need to reform legal and policy measures in regard to labor laws, including in Sri Lanka. The Employers' Federation of Ceylon, upon review of labor legislation in Sri Lanka some time ago, has observed that the Sri Lanka, being under the British rule, was heavily influenced by English law, and most of the legislation in Sri Lanka reflects the labor laws enacted in Britain during that time. However, what is unfortunate is that whilst the British have discarded many of these laws, which are now irrelevant in the context of the present socio-economic situation in Sri Lanka, has held onto them and even proceeded to further regulate rather than taking a pragmatic view of the situation and looking at what is best for our country. The main dispute resolution mechanism set out under the Industrial Disputes Act, apart from the conciliation and entering into collective agreements which relate to mutual agreement, are labor tribunals and arbitrations. Both these mechanisms enable an arbitrator or a labor tribunal to grant just and equitable relief to a workman. In terms of Section 3(1)(c) of the Industrial Disputes Act, the concept of equity is very well accepted in our law related to labor tribunals. However, the issue here is that we are still unaware the upper limits of the norms of equity and also the lower limits of the said norm when the labor tribunal exercises its own jurisdiction. Equity was developed 200 or 300 years after common law system did to resolve disputes where damages were an unsuitable remedy and to introduce fairness into the legal system. The distinction between law and equity is considered as an accident of history. The law courts or courts of law were the courts in England that enforced the king's law in medieval times. If decisions by the judges were regarded as unfair, then the litigants could directly appeal to the king, who, as a sovereign, was seen as the fount of justice and responsible for the just treatment of his subjects. Such filings were usually phrased in terms of throwing oneself upon the king's mercy or conscience. Eventually, the king regularly delegated resolving these petitions to the chancellor, an important member of the king's council. The early chancellors were often clergymen, acting as a king's confessor. Chancellery's judicial power was by the 15th century recognized. Equity as a body of rules varied from chancellor to chancellor until the 17th century, after which only lawyers were appointed chancellors. Law of equity upon their conscience. The jurisdiction of the Labour Tribunal plays a vital role in Sri Lanka. It is mainly because the Labour Tribunal is empowered to hear and determine industrial disputes based on the concept of equity. An issue has arisen as to whether, this is my issue, what I am going to place on record. An issue has arisen as to whether this concept of equity has been stretched to the maximum and sometimes even amounts to sympathy. Therefore, it is observed that the time has arrived to address this issue and to demarcate the boundaries for concept of equity in labour tribunals. I have proposed this before some other dignities also. Sri Lanka would now focus towards a new goal. Sri Lanka should now focus towards a new goal, taking labour laws to a new realm, achieving flexibility with equity. Flexibility with equity. Therefore, today it has become important to examine whether we can achieve the best results at Labour Tribunal with equity and flexibility hand in hand, and also whether there is any necessity to redefine the jurisdiction of the Labour Tribunal. Therefore, I believe redefining the jurisdiction of the Labour Tribunal and ascertaining the upper or lower limits through a practical mechanism is highly necessary. Otherwise, if the Labour Tribunals expand the jurisdiction day by day under the just and equitable umbrella, that will cause unjust to the employer or to the employee in an unspecific manner in large scale in future. Now we have to see the examples worldwide. In India, the common law doctrine of equity had traditionally been followed even after it became independent in 1947. However, in 1963, the Specific Relief Act was passed by the Parliament of India following the recommendation of the Law Commission of India and repealing an earlier Specific Relief Act. Under the 1963 Act, the most equitable concepts were codified and made statutory rights, thereby ending the discretionary role of the courts to grant equitable reliefs. With this codification, the nature and tenure of the equitable reliefs available earlier have been modified to make them statutory rights and are also required to be pleaded specifically to be enforced. Further, to the extent that these equitable reliefs have been codified into rights, they are no longer discretionary upon the courts, or as the English law has said, chancellor's foot, but instead are enforceable rights subject to the conditions under the 1963 Act being satisfied. Several jurisdictions globally have employed the principle of conscience to a greater or lesser degree in order to make a balance between flexibility on one hand and objectivity and certainty of the law on the other. Hence, the application of the principle has fostered a divergence of judicial approaches in these jurisdictions. The law, after all, responds to human needs and aspirations, even if it seeks only to confine them. Legal systems must contain remnants of earlier forms of social life that render control more palatable to the public. Therefore, I am of the view that now it is a time for us to consider of most equitable concepts to be codified and make them statutory rights of the employer, employee, or employer. The evidence ordinance, which is considered as a valuable and important piece of legislature, is not applicable to labour tribunals. There is no procedure or particular procedure code available to the practice at the labour tribunal. The applicability of common law codes have been excluded in our labour tribunal jurisdiction, merely to accommodate the concepts of equity and also to accommodate underprivileged employees to retain anybody other than a lawyer. Whether this lawyer and representative concept is functioning properly in Sri Lanka is a serious question today to be answered in the labour tribunal. An applicant enjoying the concepts of equity retains a representative to appear on his behalf. Then the powerful employer retains an expensive, highly competitive counsel who is very much thorough with the common law practice and principles. A competent lawyer always can create hidden or express conflicts between the concepts of equity and the common law, making barriers for the learned Labour Tribunal President to exercise the just and equitable jurisdiction. This occurrence itself, in my view, is a breakdown of the concept of equity in Labour Tribunal. This is only a one tiny little example in that regard. Trade unions have been extremely defensive and protective of existing legislation. We need to change our mindset. It is of paramount importance for us to accept the need for a social partnership and ask ourselves, what are the changes necessary for sustainable development and economic stability? Therefore, whatever the recommendations to improve the labor law in the country need to be made to achieve economic development, which is a prerequisite for stability and employment creation in Sri Lanka. In view of redefining the jurisdiction of the Labour Tribunal, I wish to make another recommendation, and that is to introduce a new contract of employment law or a contract of employment act. In Singer Industries Ceylon Limited versus the Ceylon Mercantile Industrial and General Workers Union and others, the Supreme Court held that for a contract to be concluded, there should be an offer and acceptance. Only then a consensus will exist in the minds of such contracting parties. For all these things, the Labour Tribunal will have to consider many facts and evidence in exercising its jurisdiction on equity. In ascertaining such facts, there can't be any flexible rules, but it is mandatory to have strict and straightforward rules. For example, to adjudge the service condition of an employee, there should be not flexible but strict and standard norms. The nature of employment can be seasonal, temporary, casual, contractual, apprenticeship, probationer, or permanent. When the service condition is not clear, the Labour Tribunal has to consider ample factual evidence in view of ascertaining to which category the employee falls. If there is a strict legislative provision which forces every employee in the country to issue with a written letter of appointment, including the correct category and all the details, then the unanimity of the orders of the tribunals can be maintained and the law of equity can be exercised in a mere effective manner with less evidence. When you make a written letter of appointment, a standard format which clearly describes the service standards is an important requirement. It gives the worker, for the first time, a right to a clear understanding of the terms upon which he is employed. He will know as an individual where he stands, and should any question arise over the terms on which he works, he will have definite evidence which can be used in a court of law. Also, he has a right to have the terms of his contract which affect him most closely set down in black and white. Then in my view, all the cases on non-extension after the expiry of the fixed term contract can be concluded within a day. This is only one example in that regard. This is especially to curtail time you spend in courts and to avoid so-called lost delays. Thereafter, we have to pay special attention to the increasing number of cases in the Labour Tribunal. Not only the Labour Tribunal, but the number of judicial review applications filed in the Court of Appeal in respect of labour matters have increased. Irrespective of the fact that the applicant or the petitioner is the employer or employee, the time period that would take to finally conclude these cases has to be taken into serious consideration. There are a number of applications made to courts in respect of matters of magnitude nature are pending in courts unresolving the core issue for a long, long time. Many occasions, these labor issues are being cropped up, in my view, due to the lack of proper leadership at the workplace. If the employer looks at the employee in a manner within the four corners of law, upholding the principles of conscience, these type of disputes can be easily resolved. In my view, most of the disputes can be resolved before going to court among parties if an access should be given to employees, enabling them to resolve the matters among the employer. My proposal in the circumstances, I propose that a special tier should be introduced to the industrial dispute mechanism, especially by introducing an adjudicator. I'm reminded the Construction Industry Payment and Adjudication Act 2012 in Malaysia. Although the said act is in reference to construction industry payment, I trust we can follow the rationale behind that act. The rationale for introducing the said SIPA Act, you call it SIPA Act 2012, was to continue with the construction works, of a site, even if a dispute arises upon an issue of payment. No stoppage of work, no stoppage of construction. Despite the changes in the law, improvement to the court delivery system facing problems in getting swift resolutions of disputes relating to payment in the course of construction project. They couldn't further trust on the commercial arbitrations. Arbitration or litigation is usually the last option when parties are unable to resolve the dispute and are ready to terminate the contract. However, in a typical construction project, disputes relating to payment commonly arise in the course of the work. As such, adjudication has come to the fore in the construction industry in Malaysia. It should be distinguished from other forms of dispute resolution such as mediation, conciliation, and arbitration. It differs from mediation because the adjudicator's duty is not to facilitate an agreed compromise but to deliver an objective decision on the dispute. It has a judicial element in that an adjudicator is normally obliged to hear both sides before making the decision. It differs from arbitration in that it is a summary process which does not arrive at a final and binding decision. An employee whose services are being suspended or who is waiting for a payment from the employer suffers together with his or her immediate family members and maybe sometimes even with parents. This unrest in the family badly affects the expected results in the socio-economic development. Therefore, in Sri Lanka also, in relation to small claims of industrial disputes, the disputes can be referred to an adjudicator appointed with the consent of the employer and the employee. Accordingly, a cluster of companies or factories, depending on the situation, can get appointed an adjudicator with the concurrence of the Labour Commissioner and with the consent of the employees to adjudicate such disputes. In this way, we can avoid parties going to court all the time, and if a strong mechanism is being introduced within the respective areas or districts, such small claims, including the issues of law, can be resolved within a limited period of time. Adopting the mode of accepting affidavit evidence before such adjudicator will curtail more time in resolving such issues. Through this conduit of adjudication, I believe that a true leadership, what I mentioned earlier, could be given not only to the employees, but even to an employer who has a petty grudge against an employee based on priceless pride. In conclusion, I would say that as the colonies gained political independence, each of their legal systems began drifting from the original in an irreversible departure from the English way of making laws and deciding cases. Nonetheless, each former colony acknowledged the reception of the common law and equity of England as a vital source of their jurisprudence. However, now is the correct time for us in Sri Lanka to open an eyes in regard to the jurisdiction of the Labour Tribunal and industrial arbitrations, including the inquiries before the Labour Commissioner. Whatever the recommendation should be autochthonous and that is homegrown and not just a copy, a foreign plan or a structure. Always we should be mindful of the attitudes of our own Sri Lankans. Our attitudes are different from the rest of the world. That is where we have to give the medicine. Thank you very much. Those are my thoughts, but there are many experts who are knowledgeable in labor law than me, including Professor Saravanesan, and I can see Sadamali is also here present today, and several other resource persons are due to arrive and share their thoughts. So thank you very much once again for the Bar Association for inviting me, and thank you very much for listening. And I wish you good luck and fruitful day. Thank you.
Thank you, sir. I think I speak for everyone when I say that it was incredibly thought-provoking. I would like to now respectfully invite the President and Secretary of the BASL and our Chief Guest, Justice Sobitha Rajakaruna, to step in front of the head table. With that, we reach the conclusion of the inauguration ceremony, and I respectfully invite the distinguished members of the head table to retire and take their places in the audience.